My lady, I have a little bit of housekeeping.
Before you embark on that then, can I take you back to just where you were?
Yes.
I was having a little difficulty following really the structure of your argument. If contrary to your submission, if we were to find that there was Flimenos-type discrimination here, essentially on the footing that the regulations treat all claimants alike, but in reality it impacts differentially on a particular cohort, however one defines it, because they have greater difficulty moving into employment so as to avoid the cap. Then when it comes to the question of justification of the discrimination, does it really come to an argument that the evidence showing a 41% greater likelihood of people just take that figure as an example, in the relevant cohort moving into work, notwithstanding the relative disadvantage they're under, constitutes a justification for the differential treatment?
So the differential treatment is that the exemption, in a sense, impacts more harshly on one group than another.
Yeah.
The question will be: is it still a rational requirement to that particular cohort? So, if the evidence was they cannot do it, therefore one would say there was no rational connection. But if they can do it, then, and if the evidence, and we say the evidence supports that, then we say there is a rational connection. So it should still apply to them.
Yes,
the real question is,
even though it's more difficult for them to do it, nonetheless, it's not impossible, and that's enough to satisfy the rational connection test.
That's a rational connection test, yes. And then moving on, and then when you move on to the other aspects, then the question is, why do you need to still apply this rule to them? Weighing up the positives and the negatives. And we say here, there is no reason why we shouldn't apply. 16 hours is per se a good rule. It's the reflection of a proper amount of part-time working. It feeds into the working tax credit system. It's a simple, well-understood system and administratively workable. Why shouldn't it apply to them?
Because it's more difficult for them to avoid the cap, as my Lord has said.
But merely because something is more difficult. I mean, you could take an example that late Baroness Hell used in SG, which is you could have a seniority requirement, an age requirement for a particular job, or you could have a strength requirement for a particular job. It may disproportionately impact on a particular group, or it may be more difficult for a particular group to apply, but to comply with it. But if it's a rule which is necessary for the business or for the organisation, the fact that it has a disproportionate impact or is more difficult for someone to comply with it doesn't mean it should be struck down, or that it means it can't be relied upon for that particular group.
What it means is that it is discriminatory in its effect, but it may be justified.
Yes.
That's what it means.
Yes. So all that it establishes is, on its face, we accept. In fact, we say it in our impact assessments and the equality impact assessments. It may be harder for lone parents with children to comply with the work exemption. But that doesn't mean we can't have it, because we think it's a good rule, and these are the reasons why we think it's a good rule: fairness, work incentivisation per se, savings, and look at what we've tried to do to make it easier for them to go into work, which is all the mitigations and the childcare costs. So it's still a good rule. And even though it applies to a group which find it more difficult to comply with it, it's still a good rule. And it's
Well, it
positive.
may or may not be a good rule.
Yes.
That's the question.
Well, is the goodness of the rule derogated from by exempting this group from its purview?
Well, so then the question would be, if they don't have to, comply with the working tax credit exemption, that they are therefore not subject to the cap. So the question is, should the cap not apply to this group?
Yeah.
That's the real question. So should the cap not apply to a group where, well, first of all, we say there's no reason not to apply it to this group because they can comply. It's not impossible for them to comply with the requirement, and the requirement is an important requirement for not just work incentivization reasons, but for fairness reasons and for savings reasons. What's being suggested by DES in its biggest part of its case is that all lone parents should be excluded from this rule. We say that would be using a sledgehammer to crack a nut, to use Miss Mountfield's analogy, where many people within that cohort can comply with it and do comply with it. The fact that there are people within that cohort who find it more difficult to comply with it doesn't mean you shouldn't use it. The question is, but what are you doing to help those people to kind of get into work? Well, we're doing a whole range of different things. And what happens if they can't get in? Are they put into a subsistence or destitute position? We say no, and to the extent that they are, DHPs are available. So the hardship to them for not being able to satisfy the rule is in a sense neutered, or is mitigated, but certainly outweighed by the positives of the rule. I don't know if that answers your question.
We'll have to reflect on whether it answers my
That is the question.
That is the question.
Before you get to that, if you have, in effect, an almost infinitely sliding scale of impacts of a particular rule upon various different people, is it enough to establish what I'll call a thliminous category, simply to establish that you can say that they are more affected, more impacted upon than others?
I mean, the test is there a significant difference?
Well, the question becomes, doesn't it, is it enough to call for an exception to be made for an identifiable category? Is that right?
If that identifiable category is significantly different from any other identifiable category,
Yeah.
yes. And so actually what the Court of Appeal did in this case was it decided the case on two grounds. It said, well, even if we're wrong on whether there's a significant difference, it is justified. And that's what I would urge on you. But where you're dealing with, the question is, should the 2-year-olds be treated differently from the 3-year-olds, and so forth. And part of the analysis is if you take out one cohort, what's the impact on the overall measure and the overall aims that are generally regarded as legitimate aims?
All right, thank you.
Thlimenos itself, as you say, was fairly clear-cut category. Are there cases in the authorities which apply it to this sort of sliding scale situation?
I'm not familiar with any that are, and I'm sure it's not a case which has actually been developed. I mean, it's being used, but it's not been developed considerably within the case law. I don't think there's a lot of Strasbourg decisions on it. I think it was very much a peculiar facts of that particular case, but it recognises the principle that different people in different circumstances shouldn't be treated the same.
That's very basic. Yeah.
But ultimately, it will come down to justification if you fall within the a potentially exempt category, and what is the impact, in a sense, on the rule itself if you exempt here 56% of the cohort or 78% of the cohort. Depending on which one you look at, you are emasculating the policy. All that the policy will apply to would be couples with children and single people, and it would undermine the fairness objective, work incentivization for many in the cohort who do not find it difficult, because we know that 11% go into work anyway. We know that 19% go into work as a result of the at the cap or were going into work anyway. So those are the things that you need to consider.
Mr. Sheldon, if we were considering a violation of Article 8,
Yes.
and if we got on to proportionality, we would have to consider legitimate aim, rational connection, least intrusive option, and fair balance. But we're not looking at a violation of Article 8. We're looking at, if we get this far, justification for Thlimenos-type difference.
Yes.
In those circumstances, are we compelled to analyse it in terms of the fourfold inquiry that would be relevant to an Article 8 proportionality inquiry?
We say no. One doesn't have to look at it that way. It's just the courts have developed different tools, analytical tools, as they're going forward. The test that we say you need to apply, which is actually the STEC test, is manifestly without reasonable foundation, as applied by the 7 judges of this court in Carmichael. They didn't break things down into the four-stage test. That's just an analytical tool, not required in every case. But you do need to step back and say, is this discrimination or differential treatment or non-differential treatment manifestly without reasonable foundation? And that would include, obviously, as part of your analysis, what's the point of this rule, how does it apply, what's its impact, and so forth. But you don't need to go through the particular analysis.
Well, as I said, it may be helpful, but you say it is not requisite.
It's not requisite. It's not required. It's not required.
Thank you.
Well, you do undoubtedly have to ask whether there is a legitimate aim and whether the measure is a proportionate means of achieving that aim, don't you?
But I mean, that's looking as to, is it manifestly without reasonable foundation? You'd be asking yourself, are they doing something which is reasonable for them to do, and are they doing it in a reasonable way? That's really all you need to be asking.
Well, just following Lord Reed's question, if no one is alleging a breach of a substantive right, is it right to say that you look at legitimate aim and then proportionality in relation to the substantive right? Or do you look at whether there's a legitimate aim and whether the discrimination that the measure's achievement of that aim brings about is justifiable, is proportionate?
I mean, ultimately, it all means what does justifiable mean, and how do you describe that?
But I mean, in some cases, some forms of discrimination, what you're challenging is the justifiability of the measure itself.
Yes.
In Thlimenos discrimination, what you're looking at isn't the measure, but in effect, whether there is a failure to exempt people from that measure in the context we are talking about.
Yeah.
In that context, does one need to determine more generally whether the measure while it must achieve a legitimate aim meets the other aspects? I mean, to answer a Thlimenos question, do you need to carry out an assessment as if it were breaching a human right?
You're looking at it differently, because you're not looking at a substantive breach. Yes. Where there will usually be a provision like 8.1, 8.2, which gives you the questions of what are the legitimate aims and so forth that satisfy it. Article 14 does not include that language at all. But if we look at Thlimenos itself, which perhaps is probably the best to go back to the original source in Authorities Volume 12, tab 106, it's MS 4192. They do ask the question at paragraph 46, the Strasbourg Court, is paragraph 46, once they decided the question of, they set out the question of significantly different, they do say, does the failure to treat the applicant differently differently from other persons convicted in a felony pursue a legitimate aim? If it did, you'll have to examine whether there was a reasonable relationship of proportionality between the means employed and the aim sought to be realised. So they do ask, is there a legitimate aim at all in still requiring, imposing this sanction essentially on the Jehovah's Witness, not allowing them to be a chartered accountant? And if so, is there a reasonable relationship of proportionality? So in our situation, one would be saying, is there a legitimate aim in maintaining the work exemption, the 16-hour work exemption for lone parents? And if so, is there a reasonable relationship of proportionality between that aim and what you're seeking to do?
Well,
Is Sir Patrick wrong? Paragraph 92 of the Court of Appeal. Second sentence. If you're talking about thlymonos, you're talking about whether the difference of the thlymonos category demands an exemption. Is that right?
Yes.
What he then goes on to say is that assumes the legitimacy or the propriety or the lawfulness of the measure as a whole, and you're simply concentrating on whether there should be an exception to it.
Yes.
If that's right, does that help answer Lord Hodges' question about whether, if you're simply asking whether there is a necessity for an exemption, you need to examine the legitimacy of the aim of the measure as a whole? It may be relevant to asking whether there's a need for an exemption. Of course, you're bound to look at what the aims are in order to see whether there's a need for an exemption. But I wonder if it helps at all, if he's right, to answer the question that Lord Hodge asked.
Just going back to thlymonos itself,
Yeah.
which I think has got
Yes,
sort.
that's what you wanted us to do.
Well, I think it's the analytically correct thing to do. It's they asked this question. The court asked this question at paragraph 46. The court will have to examine whether the failure to treat the applicant differently from other persons convicted of a felony pursued a legitimate aim. If it did, the court will have to examine whether there was a reasonable relationship of proportionality.
Yeah. So that's the aim of the non-exemption.
The aim of the non-exemption, which is essentially the aim of the rule.
May well be.
Which is how I think Sir Patrick Elias characterises it in 92.
Okay.
And what is said in thlymonos seems to be consistent with what the Grand Chamber said in Carson. And the neatest source for that is MS 342 in SG in paragraph 7 of Lord Reed's judgment, where he quotes it, where it seems to me a similar formulation is being adopted. The difference of treatment is discriminatory if it has no objective or reasonable justification. In other words, if it, i.e. the difference in treatment, does not pursue a legitimate aim and there is no reasonable relationship of proportionality between the means employed and the aim sought to be achieved.
And thlymonos simply means you change the word difference of treatment to failure to treat differently.
Does the failure to treat differently pursue a legitimate aim, and is that reasonable? So we say the legitimate aim here is the threefold aim that they still apply to this particular cohort. Yeah. In thlymonos, it failed because the basis of the prohibition to become an accountant was on, have you been convicted of a crime essentially of moral turpitude, and how can that be right when you were a conscientious objector?
Absolutely.
So therefore, you're not actually doing anything. You didn't do anything which was within the aim. So therefore, of course, there's no reasonable relationship. It can't be proportional. We're in a very different situation where we say the underlying principles still apply to the entire cohort or whichever cohort we're looking at, albeit one can say that they are more harshly treated because it's harder for them to actually comply or satisfy with it. But can they work? If the answer which in a sense was the way Mr. Justice Collins was trying to get to, perhaps, in the High Court, was it's impossible or virtually impossible for them to work. Then how can you be requiring them to do 16 hours? Then you're into the Philomenos type situation on that one ground.
Yes, but the point I'm making, the coherence of the system perhaps is improved if you get into the ambit of an article of the ECHR without interfering or breaching a right, then it's hard to see in an Article 14 question why you should be answering whether or not the four questions of proportionality, which are directed to a breach of the right. Rather, you should be asking, does the discrimination pursue a legitimate aim, and is it proportionate that discrimination exists?
My Lord, my only point to add to what you're saying is Article 14 is itself a right.
Yes, of course.
Under the Convention, and it would be a breach.
Yes,
but
Yeah, so the context is different, but the same questions are still pertinent, surely.
Well,
I mean, the context is you're trying to justify the discrimination as opposed to trying to justify the interference with the substantive right.
Yes.
But justification still calls for, surely, the same intellectual exercise.
it certainly calls for an intellectual exercise of legitimate aim and proportionality.
Yes.
But whether one needs
proportionality covers
Well,
the other three elements.
well, whether it does or it doesn't, in a sense, it's...
Yeah. I think the quotation from Philomenos from Carson in Lord Reid's judgment in SG probably puts the matter, at least to my mind, beyond doubt. Probably spent enough time on this particular
although he's not dealing there with a Philomenos type case. That's all. Well, luckily these are matters for you to decide rather than for me. And there were some housekeeping matters, if I can just quickly take you through those. I was asked about, by Lord Carnwath, about references to Harvey, where I said he accepted the statistical, the causation. It's MS 5086 to 5087. It's paragraphs 33 to 36. He accepts it subject to some statistical kind of caveat, but he does accept it in substance. Lord Wilson asked me about whether there's any material about an analysis on DHPs, local authority by local authority. How do they allocate them? What we do.
Well, not exactly how they allocate them. Consistency between local authorities. I mean, putting it crudely, is it a postcode lottery?
Well, we don't have. There is no evaluation evidence that I'm aware of.
No.
Certainly not in the bundle, which answers that
Very well.
question.
Thank you.
Then there was a question, or I was seeking to make a point about working a few hours, and I said it was referred to in Mr. Edson's witness statement. We find that in Mr. Edson's witness statement in DS, second witness statement, at paragraphs 24 to 28. It's at MS 6958 to 6959. And in respect of Lord Reid asked about, or someone asked about whether or not we have up-to-date statistics about child benefit and child tax credits and the impact on the I thought someone in the court had asked that. We don't have them to date, but we can provide those. Then you were shown this morning, I think it was handed up, Regulation 2 of the Housing Benefit Regulations, which dealt with single claimant, so you could understand how we got into why why lone parents achieved the higher cap. But also in that document, that was handed up to you. And there's another document that's just been put on your table. There will be a way of explaining how we get to the working tax credit point. So working tax credit, if you have an open working tax credit, you are exempt from the regulations under 75E2. And Regulation 2 of the Housing Benefit Regulations, I think it's over the page, or over a few pages, defines working tax credit. Yeah, so it's at page 19 of your clip. It means a working tax credit under Section 10 of the Tax Credits Act. And then what you've been handed up is Section 10 of the Tax Credits Act, which talks about entitlement, being engaged in qualifying remunerative work. And at Regulation 4, the second condition talks about, in the case of a single claim, undertakes work for not less than 16 hours per week and is responsible for a child, etc. So it's Regulation 4 of the Working Tax Credit Entitlement and Maximum Rate Regulations 2002. If I can move on as swiftly as possible, if I just want to deal with the proposition that was made by the EHRC that the policy was a sledgehammer, which was bad at cracking nuts and causes a lot of collateral damage. That's the way it was characterised. Well, we say once you properly understand the aims, two of which were completely ignored by the EHRC, there is no collateral damage at all, because in every case, the fair overall limit will have been imposed. So the fairness of the overall limit applies, whether or not you can work, go back to work, or you don't go back to work. But also in every case, work will have been encouraged, and whether or not you do in fact go into work, and that in itself is a legitimate aim and a reasonable one. And in some cases, it will result in work, whether or not it's in fact 16 hours. It may be less than 16 hours. And then just to finish on this point of incentivisation, I just want to remind you of Lord Reid in SG essentially dealt with the question of ability to work at paragraph 74 of his judgment. But ultimately, it is not impossible or virtually impossible for the under 2 cohort to get into work, and certainly as one gets higher up in the age range about getting back into work. So therefore, to exempt the entire cohort of lone parents, we say would be an inappropriate judicial response to the cap, but also the same with respect to other cohorts. I need to move on swiftly. Fiscal savings, we've dealt with that we deal with that in our case between paragraphs 254 to 258. I'm just going to give you some very brief headline points so that I can move on and deal with some of the other matters. One needs to look at two things here, not just the immediate savings, which do run into the hundreds of millions of pounds, but and you see the statistics in the impact assessments and the latest impact assessments, so the 2015 and 2016 ones, use the language of additional savings, and that's been ignored by the appellants. They talk about the additional savings over and above the original cap. Then, as well as the immediate savings, there are also the long-term savings, because one of the key points behind the policy is to change what is described as the welfare dependency culture. And if people are moving into work, then they are changing the culture. And we've seen the evidence, the 41% evidence, that is happening. And secondly, it will impact, we say, on the lives of the children who will have the modelling behaviour of their parents being in work. And that will have a long-term impact. This is not the only thing that the government is doing to address the issue of welfare dependency and improving education, providing childcare, free childcare for disadvantaged children and so forth, and equalising the availability of childcare with the more advantaged is another aspect of it. The fact that we're dealing with a very large welfare budget, which runs into more than £100 billion, and what is being sought to save here is hundreds of millions, in a sense, is not material, because saving hundreds of millions of pounds at a time when the government is and certainly was and still is concerned about the budget deficit, is important. And it's not just important for today's generations, but also for future generations. So I think there's not much more I can say about fiscal savings other than, are savings a legitimate aim? That was the subject of a discussion by the various members of the court in SG, and I urge on you Lord Reed's analysis where he dealt with the case of O'Brien and a number of other convention cases. That was a case from Luxembourg, but he also deals with convention cases.
But could I just ask you, whether there's actually, I'm asking everybody really, whether there's any robust social science research about whether there exists a long-term welfare benefit dependency culture of the sort pilloried in various television programs amongst lone parents.
I'll have to take instructions on that. What we do have, and I don't want to get into the detail of the cases, but I think there is at least one of the appellants has, I think her oldest child is 13. Mm-hmm. It's one of the appellants in the DS case, and she says she has never worked. I think she has, and she says that in her statement. She has never worked. Now that may be, this is not a I can't say that's a widespread piece of evidence, but there's an example.
Well, never working is not the same as welfare benefits dependency. It might be other sorts of dependency.
There may be other reasons. I'm just that I don't know the answer to your question, and
I just wondered. It's just crossed my mind.
We will find out for you
because of all the emphasis that there is on, and I completely understand that.
Yes.
No problem with.
I'll understand if there is
some
research.
Concerned about that aspect of the matter, and also, of course, setting it against depriving the children, especially very young children, of the full-time care of their parent, of any parent, because by definition we're talking about a lone parent. Now, for most of my life, it has not been thought a good idea to separate especially very young children from the care of their mothers. So, again...
My lady, what we are dealing with here is a 16-hour work requirement out of 168 hours a week. What we would say is encouraging a lone parent, even of a very young child, to go into work for 16 hours, even adding in some travel time and so forth, is really can't be said to be depriving the child of the care of his or her lone parent. So we say there are 3 legitimate aims. Each of those aims is rationally related to the cohort of lone parents or the sub-cohorts. And there is no other means of achieving the aim without including these cohorts within it. To take them out, you can just see from the statistics, would unacceptably compromise the objective. That is more extreme depending on how large a cohort one is prepared to remove. So before considering the UNCRC, we say plainly there is a reasonable foundation to the measure, whether we are looking at the overall cap or whether we're simply looking at the 16-hour work exemption. The aims that the government and parliament are seeking to achieve are legitimate, and they apply to and are materially relevant to each of the cohorts. There's no reason to exempt any of them. We can't say that it's manifestly without reasonable foundation not to exempt any of these cohorts, even when one considers the effects or impact on the particular cohort or some of the children within that cohort. The cohorts can, in principle and in practice, work and therefore escape the effects of the cap even though it's harder for some than others, and there may be difficulties in the way. But where there are particular hardships and barriers, we say DHPs are available, as we've seen on the facts here. We're not saying that DHPs provide a complete answer to every case of a person caught by the cap, because otherwise that would defeat the purpose of the cap. But they are an answer to the hard cases which are evidenced in front of you. This is not a situation, we say, where those who can't receive DHPs, because they're not available to everyone, are in a position where they ought to receive DHPs because they would otherwise be at a subsistence level or at a destitute level. So those are my submissions on the pre-UNCRC submissions. So then if we deal with the UNCRC, there is I want to take you to the case of SC, which is a decision of Mr. Justice Ousley, Volume 9, Tab 74. I'll give you the MS number. It's MS 3007. It's a decision concerning child tax credit and whether or not that can be made payable to families where they have more than 2 children. In the course of that decision, which was handed down a little bit earlier this year, there was discussion of the UNCRC, and it makes, I think, useful reading, and I certainly invite you to look at the entire case, but also the analysis of the learned judge of the UNCRC. But I just want to pick it up at paragraph 214, MS 3071, because there's a number of points that were raised on behalf of the Secretary of State there by Treasury Counsel, which the learned judge did not need to decide upon, but he says he was inclined to accept them. But I think they are important for you in terms of considering this question of the role of the UNCRC. First point, so it's at the bottom of 3071, Strasbourg has not gone so far as to use the UNCRC as mandatory hard-edged rules relevant to determining justification under any article, particularly in view of its manifestly without reasonable foundation test. Its focus is harmony and the quality of decision-making. It has not incorporated, and I adopt these submissions, it has not incorporated the UNCRC into Articles 8 or 14, adopting hard-edged rules from the UNCRC, even more so if the general comments are used, as if they were parts of the UNCRC itself, would undermine the flexibility which that test creates. Strasbourg has gone no further than Demir and Turkey, which is an orthodox application of the Vienna Convention. The domestic courts should go no further than the established Strasbourg jurisprudence. Great caution is required about importing the UNCRC to rewrite the European Convention and create a body of rules of non-compliance with which would show discrimination or other interference in an ECHR right not to be justified. The UK has a firmly established dualist approach to international treaties and domestic law.
I think we can hear Sir James making these arguments.
Well, these are the arguments made there, and I invite you to read those.
Yes.
But they are important when you are considering my submissions on the UNCRC, because they are put better there than I will possibly be able to make them.
You don't need to be so modest, Mr. Sheldon.
But they are important, because the next point, and I will pick up the next points. What we say in respect of the UNCRC, firstly, it should not be used to usurp the manifestly without reasonable foundation test. That is not what Strasbourg has done in any of the cases where the UNCRC has been mentioned, and those cases are relatively few. the different appellants in this case have suggested that it is either determinative or it could be determinative, or it's very highly material. We say that is not correct, because that would essentially be replacing the manifestly without reasonable foundation test with a test requiring compliance with Article 3. That would go beyond any reported Strasbourg case. In X and Austria, what was said was harmony. The decision that they were reaching was in harmony with the best interests. It would also go further than any domestic law case. That is not what my Lord Wilson said in Mattison. He dealt with the issue of harmony. What Article 3 is an interpretative aid. It cannot usurp the test. And that's the context in which I make my submissions. Now, we say there are, in fact, 4 different interpretations of the UNCRC Article 3, which you should be considering and which I will submit are tenable interpretations. Our primary interpretation gives an outer limit to the words actions concerning. Because we're dealing here, and if we just pick up the UNCRC in tab 7, MS 58, the article that we're looking at is, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, admin authorities, or legislative bodies, the best interest of the child shall be a primary consideration. So what do actions concerning mean? We set out our primary interpretation of this at paragraphs 301 to 305 of our written case. We say that those words do not include general legislative measures which are not addressed to and do not change any legal right or entitlement of the child, and whose practical impact upon the child is indirect and contingent upon a wide variety of circumstances and choices. It's too tenuous. We put that point, but in the further submissions of the DA appellants, they say, well, that's inconsistent with UN committee guidance. But the comment, we know, is not law. And I can't put that better than the way that Mr. Justice Ousley put it in the case that I was seeking to take you to a little bit earlier.
You did take us to it.
Well, I took you to, but I didn't take
read
you.
it.
I didn't take you to.
Well, we read the paragraph you
You need to look at paragraph 213, but we set it out at 296 of our written case. And there we say, 296, this is what Mr. Justice Ousley says, there's a real danger in treating the general comments as themselves being the UNCRC language when they're not, and still less are they the language of the Convention. Their analysis is not apt for direct or precise application in each and every issue in any event, nor are the general commentators the guardians of the meaning of the UNCRC, reaching conclusions after forensic debate involving the signatory states. Neither Strasbourg nor the domestic courts here are required to decide the meaning of the ECHR or compatibility with it of domestic legislation by reference to such sources. The illumination they afford needs careful judgment. It may not illuminate the real issues, but become a mistaken focus. And in any event, when one looks at the comment of the Committee on the Rights of Children at paragraph 20, which you find at MS page 76, so it's in the next passage, is it in tab 8? It says, indeed, this is the committee's language, indeed all actions taken by a state affect children in one way or another. This does not mean that every action taken by the state needs to incorporate a full and formal process of assessing and determining the best interests of the child. However, where a decision will have a major impact on a child or children, a greater level of protection and detailed procedures to consider their best interests is appropriate. Thus, in relation to measures that are not directly aimed at the child or children, the term concerning would need to be clarified in the light of the circumstances of each case in order to be able to appreciate the impact of the action on the child or children. We say, from that comment, if we are looking at the general comments, we say that means that tells us that a full and formal process of assessment is not always needed. Article 3 cannot apply to everything, even if everything ultimately affects children. So our general submission and our primary submission is that the words actions concerning should not be construed to mean general legislative measures concerned with reducing benefits paid to adults, not children. And if we're right on that, if that is a tenable interpretation, Article 3.1 is not engaged at all. Our second interpretation, which we say is also a tenable interpretation, is to say, and we set this out at paragraphs 306 and 307 in our case, and of course I'll ask you to look more carefully at the case, is to say that even if Article 3.1 is engaged, it does not, on a proper construction, require the kind of assessment that Lord Carnworth called for in the SG case, nor does it require the three rights set out in the comment, the procedural and the substantive and so on, when dealing with this measure. In this regard, we rely on Lord Hughes's approach in SG and also the general comment at 20, where the level of consideration will depend on, are the children targeted? They're not. And is there a major impact on the children? The answer to that is it depends. We deny that there is a major impact on the children in the cohort generally. And we also say there is not necessarily a major impact on any child whose parent is subject to the cap. It just depends on how the parent responds. If that is the correct interpretation or a tenable interpretation, we have plainly complied with that in this case. There were 4 questions discussed by Lord Hughes, which had been put by Mr. Wise on behalf of the appellants in SG. They were recorded at paragraph 153 in SG. If we can turn that up, that's in Authorities Volume 2, behind tab 16, at 153. Sorry, I apologise, it's 154. 154, I had the wrong reference. MS 382, 4 questions. Lord Hughes observes that the principal submission of Mr. Wise was that the Article 3 obligation required careful consideration of how many children will be or likely to be affected by the cap, asking what the effect on those children particularly affected by it would be, asking whether the cap could be implemented in a manner protecting such children from adverse effects, and asking whether the general proposition that the cap will lift children out of welfare dependency outweighs the risk to those particularly affected. Now, we don't say that those are required questions, but if they are required questions, as part of the procedural obligation under the UNCRC, we say that through the various assessments and evaluations that I've shown you, we have answered those questions. And we set that out at 323 of our written case. It is suggested by DA in their, certainly in their written submissions, their further submissions, that they say we can't show any degree of consideration of the best interests of children. Well, that simply ignores a whole chunk of our case, which is Section E and the materials that I took you to earlier today. On any view, the question of best interests was referred to throughout the proceedings, and I said it was a thread which runs through the various documents that were prepared by government and available to Parliament. And just reminded that Lord Carmouth asked about impact assessments. What I've been able to learn so far is that they are, when they're published, they are laid in the House of Commons library and made available on the parliamentary website.
Okay.
The third interpretation is that of Lord Carmouth in SG, where Lord Carmouth treats the comment as authoritative guidance, accepts there may not need to be a structured order in the way that the questions are put, but set out at paragraph 108. MS 369. The evaluation needs to consider, where relevant, the interests both of children in general and of those directly affected by the action. It also needs to indicate the criteria by which the high priority given to children's interests has been weighed against other considerations. Insofar as that evaluation shows conflict with the best interests of the children affected, it needs either to demonstrate how that conflict will be addressed, or alternatively what other considerations of equal or greater priority justify overriding those interests. Now, that approach does not guarantee any particular substantive outcome. The substantive right, which is referred to in the comment, goes to the process of assessment, but doesn't guarantee any substantive outcome. Under the UNCRC, the substantive outcomes are dealt with in Articles 26 and Article 27, not Article 3. If Lord Carmouth's interpretation is right, and of course we make two prior submissions, we would also say, looking at our paragraph 323 in our case, that there has been substantial compliance with the questions that were put, or with the structure that was put, albeit we haven't indicated the criteria by which the best interests of the children have been weighed against other consideration. But we have looked at the best interests of children. We have made it very clear as to what we consider the best interests of children are, but we have recognised the interests of those children who are affected by the cap, and where their parents cannot, and particularly lone parents, cannot escape the cap. The fourth interpretation is that of Baroness Hale in SG, which we address at paragraphs 308 and 309 in our case, where, if we understand it correctly, what is being asked is, under the UNCRC, is, does the cap deprive children of the basic necessities of life? And if so, if not, that this outcome establishes a breach of Article 3. We deny that the cap does this. We would suggest, respectfully, that this is not the correct interpretation of Article 3, because the issue of outcome is dealt with at 26 and 27, albeit subject to the caveats that I've mentioned earlier today. One cannot read Article 3, which is essentially an interpretive provision or a procedural provision, to achieve an outcome. However, we say at most it's a further interpretation. So what you would have here, we say, are 4 different interpretations of the UNCRC, and you may have others yourselves.
I mean, your main point is that we shouldn't have been doing this at all. The trouble was, at the time we were studying this, it had been conceded that the convention was applicable. Yes. And so we wrote our judgments on that basis. Then that concession is withdrawn. I'm afraid, rereading my judgment, I can see how it reflects that slightly unhappy state of affairs. But I mean, your primary submission, which ties in with what was said by Justice Ouseley, or by Mr. Sir James Eadie, is that really this is the problem about a national court trying to interpret the convention.
Yes, yes. When one is, but we're dealing here, the UNCRC is an unincorporated treaty. Where it has been brought into domestic law, there is specific statutory provision for it, such as in the Children Act and in one of the Immigration Act, the Borders and Immigration Act. It is not, has not been incorporated into the social security legislation. So we're dealing with an unincorporated treaty which has not been interpreted by any international law court. All that we have are some comments in a number and in a few Strasbourg cases. And of course, where it's been most likely to be used has been in cases involving individual children, where there are questions of adoption or extradition and so forth, where one can look at an individual child. And what Strasbourg says is questions of harmony. What one wants to interpret the convention in harmony with international treaties. But the interpretation of it has not been decided by an international court. What we have, of course, are some comments by the committee. So we say, yes, it shouldn't be really looked at by you at all in this case. That doesn't mean that it might not be able to be looked at in other situations. We're not saying it can't be looked at in any situation. But when we're dealing with a general legislative measure, particularly one which is not directed at children, it's not directed at children's benefits, it may have an impact on them depending on how the intermediary, their parent, responds, then we say you should avoid using UNCRC at all. However, even if you consider, look, there's a whole series of interpretations, what do we do with it? I want to remind you of the corner house principle, which is referred to by Lord Reid in SG. I think we picked that up at paragraph 90 of Lord Reid's judgment. Paragraph 90. It is firmly established that United Kingdom courts have no jurisdiction to interpret or apply unincorporated international treaties, referring to the case of Rayner, Lyons, and Corner House. And then there's a quote from the two judges in that case. And if you want to see Corner House in full, it's in volume 6, tab 50, MS 1934. But for my purposes, we only need to use these two particular passages. Lord Bingham, whether in the event that there had been a live dispute on the meaning of an unincorporated provision on which there was no judicial authority, the courts would or should have undertaken the task of interpretation from scratch, must be at least questionable. Should the court be doing this at all? It would moreover be unfortunate if decision makers will be deterred from seeking to give effect to what they understand to be the international obligations of the United Kingdom by fear that their decisions might be held to be vitiated by an incorrect understanding. Lord Brown expressed himself more emphatically. It simply cannot be the law that, provided only a public officer asserts that his decision accords with the state's international obligations, the courts will entertain a challenge to the decision based upon his arguable misunderstanding of that obligation and then itself decide the point of international law at issue.
Well, I was responding there to an argument that Lord Carnwath had raised, that a misunderstanding of the UNCRC would be an error of law vitiating a decision on conventional administrative law principles. I mean, obviously, I accepted elsewhere that the Demir principle applied in relation to the interpretation of the ECHR, and one would take account of the UNHCR in that context.
Well, our submission is it can, in some contexts, be relevant to a Demir type analysis, but not in every case. But where there is a tenable interpretation of international law, which the UK government has been applying, then that is one that this court should not interfere with. But in any event, when we look at the particular facts of this case, irrespective of which way you see the role of the UNCRC, what relevance does it really have to the questions in front of you? The legal issue in this case is whether Article 14 has been breached. Depending on how you answer the questions of ambit, status, and so on, it may may or may not be possible to articulate discrimination claims on behalf of the children as well as the parents. But even if we get into issues of whether children can bring a claim, we say Sir Patrick Elias was right in his decision, in this case, in DA in the Court of Appeal, because really the discrimination of any discrimination in this case is the treatment of the parents, not of the children. The regulation for 16 hours that we've been talking about this afternoon is directed at the parents. It may have an impact on the children depending on how they respond, but it's not treatment of the children that we're concerned about. What we have here is at most an indirect, contingent impact of the cap on the child. And we ask the question, in that context, how can Article 3 really illuminate or add to the justification? Unless there's anything else I can assist you with on the UNCRC, those really are my submissions on that point, which is I'm essentially urging on you to analyse this case without the UNCRC. But even if you were to look at the UNCRC, it doesn't, we say, add anything, and it can't usurp the manifestly without reasonable foundation test. It doesn't allow you on the facts of this particular case in any event to achieve, to arrive at a different answer. My lady, my lords, there is then a question that is raised, a challenge raised on the grounds of irrationality. It is contended that the decision of the Secretary of State was irrational. Obviously, the irrationality challenge can't be directed at the statute, but it's being challenged at the delegated secondary legislation. Of course, I remind you of Lord Sumption in Bank Mellat, where he makes the point that one needs to give considerable deference to a decision of delegated legislation, given the way in which it's enacted. And we have seen here there was particular scrutiny of this legislation. In fact, there was a vote on the legislation which failed to stop the regulations coming into force. The question then is, what is the test of irrationality? How should it apply here? Well, we say, and we had understood that what was being suggested in this case, or what was going to be put in this case, was that the court should abandon the Wednesbury unreasonableness test and apply proportionality across the piece. My understanding now is that's not the way the case is being put. What we have, if we're looking at irrationality, we should be looking at it, the court should be looking at it in the same way as you would look at a standard common law irrationality challenge, which is it Wednesbury unreasonable? And on that basis, plainly, we say the decision is not Wednesbury unreasonable, and the irrationality challenge really adds nothing to the Article 14 characterisation that it is then said, well, no, we want to put this actually as a Tameside case. You can look at it as, did you ask the right questions to get the right information? That challenge failed in the JSSG case at first instance, and wasn't proceeded with on appeal. And we say a fortiori here, where there's even more consideration of the relevant questions and the relevant information is being evaluated than before the cap originally was introduced. But if you are asking the Tameside questions, what information did we seek out? Did we get enough information to ask the right questions so that we could reach and make the appropriate answers? Look at what we did. And my learned friend, Mr. Wise hadn't taken you basically to anything that we had done when he made that submission. I also remind you in this context that there was no challenge here under the public sector equality duty. Again, they could have challenged it on that basis. Undoubtedly didn't challenge it because we looked at the equality issues in some considerable detail. But what's being said is, well, you can take it into account when you're looking at irrationality, whether or not we did comply with those duties. Well, insofar as you could take that into account, we plainly complied with those duties. We asked all the right questions around equalities. It's then said, well, the rule is irrational when you compare it with the other exemptions. And the particular focus is on the comparison with carers. And you will note that in the regulations, one of the exemptions is for those in receipt of carers' allowance. But to receive carers' allowance, which is a benefit, the recipient has to care for 35 hours a week. That is a precondition of the payment of the benefit. That 35 hours of caring, for which the state provides a benefit, that 35 hours may also be accompanied by not only more caring than the 35 hours, but also the carer may have other responsibilities for looking after their own family. And in the Hurley case, which is where there was a challenge to the failure to exempt carers, this was a Thlimanos case essentially. Why were carers not allowed, carers outside of the household? Because in the original regulations, carers in the household were exempt, but carers who were caring for someone who didn't live in their household weren't exempt. And there was a category of about 2,000 people. One of the carers who brought the claim was herself a lone parent looking after several children, but she was caring on top of that. So the 35 hours has to be, and that won't be unusual, the 35 hours has to be considered in the broader context. But yes, of course, if you have to care for someone for 35 hours a week, albeit that may be your choice to do that, because as was said, well, you could always put the person in a care home, it will significantly impact on your ability to gain full-time employment or even to find 16 hours of work. You have to do the caring. And on top of that, you would be required to work at least 16 hours. That's not to say that parents do not care for 35 hours. They may well care for many, many more hours than 35 hours. But they don't get paid for caring. And what is provided by the state is, as we've talked about before, childcare costs, and of course there's the provision of schooling, where and certainly free childcare for those over 2, but also the childcare costs for those under 2, as well as others. The state makes it easier for you to go out to work. It mitigates any of your difficulties.
The mother of a toddler will be exempt if she goes out to work to look after somebody else's toddler, but not if she stays at home to look after her own.
If she goes out and is paid, if she works for 16 hours looking after someone else's toddler, then she's exempt from the cap. Yes. And but she doesn't have to work 35 hours a week looking after someone else's toddler. But it's a different one, isn't the state is paying people to care as on one view it's almost symbolic, because it may not cover it wouldn't be the wage that you would receive as a carer, but it's a very different type of caring arrangement, And secondly, the cohort is a much more minimal cohort. The size of that particular cohort was in the low thousands. Here, we know that the cohort that they're seeking to exempt is a much, much larger cohort. So we say it's not irrational even to look at the other exemptions not to have excluded from the cap lone parents with children under 2 or any other form of lone parent. We've also had raised against us the Convention on the Elimination of All Forms of Discrimination Against Women, which we deal with in our case at 330 to 331. That's at MS 8488. We say it adds nothing to the justification analysis because that convention is only breached if there is unjustified discrimination against women. So it presupposes that you haven't been able to justify what's already taken place. So it's otiose. It is suggested by DS in their case that the evidence doesn't appear to assess or take account of the negative impacts on women on being subjected to the revised cap, whereas lone parents with children, they are least able to escape its effects. Well, as we say here, we don't accept that lone parents are least able as a class to escape the cap. All of this depends on the circumstances. We recognise that being a lone parent is plainly relevant, but it doesn't mean that they are a class who are least able to escape the cap. It all depends on the circumstances. And as we've pointed out, there may be a lone parent with 1 child, with easy access to childcare, family support, available work in their location, and they might find it relatively easy to find 16 hours or even a lower number of hours. That could be contrasted with a couple with many children who have no family support, less available work and childcare in the area. They might be worse off in comparison. And of course, as I've taken you earlier, the equality impact assessment specifically did address the impact on women. So to suggest otherwise is plainly wrong. Okay. So my lady, my lords, unless there's anything else I can assist you with, I think I've actually finished.
Quarter an hour ahead of time.
Well done.
Thank you very much indeed, Mr. Shelton. Mr. Cornwell?
My lady, I am just reminded that we haven't responded to the notes that have been put in, and we will produce as soon as we can a short note if there's anything that we need to say.
I mean, it may be that you're perfectly happy with it, or you may have killer points to make about it.
Thank you very much.
Yes.
Can I start with some short submissions, and we're going to have to be short anyway, about whether the figures in the revised cap are arbitrary. I know that Mr. Sholem took you to a lot of the material in the impact assessments and the equality assessment to show the matters that were considered. But our submission remains that the missing and crucial element is the assessment of the acceptability of the actual figures in the primary legislation as reflecting an acceptable standard of living, which is at the heart of Malone Friend's case. Malone Friend's case is that the government decided that the figures in the primary legislation were satisfactory in terms of providing enough to live on. I've forgotten what the exact phrase is.
Didn't we read that the government sought to justify the figures on the basis that 40%
That's exactly.
of working families managed on these limits.
That's the point. That's precisely the point I'm coming to, because it comes back to a theme which CPAG has been putting forward throughout the life of this cap. We submit that despite the approach in the equality assessment and the impact assessments, the figures are arbitrary. That doesn't necessarily mean they're wrong. I'll come back to that in a moment. But he says correctly that the figures are apparent on the face of the bill, and the government says they're enough to live on. But one, the figures are the figures in some way related to the living standards of the 40%. That's the point that your lordship is just putting to me. Well, the short answer is no. The answer to the question, the repeated formula in the impact assessment and in the equality assessment, and in paragraph, it's actually 77 of the memorandum to the Human Rights Committee that we were looking at close of play yesterday, effectively, is that the figures reflect the earnings of the 40%, bottom 40%, obviously. No criticism of that. So my learned friend says, well, that's a virtue. They're recognizing that they're linked to earnings. I say it's very far from a virtue, because what it means is there's been no attempt to look at the resultant living standards that that 40% would reflect, and there is no analysis. Now, it's the way I think about this, because of a certain age, is to think about tax allowances. In the old days before child tax credit, someone in work would have had a married person's allowance, if they were married, a single tax allowance of some sort, and they would have a child allowance offset to reduce their tax bill. That's now become child tax credit, as Baroness Hale sets out in Humphreys. So the effect of that on living standards is being lost if you look simply, but in the current system, is a earnings figure and not an earnings plus benefit figure. You're missing out any household size assessment out of the tax or benefit system. So at that stage, if you simply refer to 40% of earnings, you are not comparing a living standard of those in work with the living standard who you are leaving subject to the cap. There's a flaw at that point. And second and follow-up question is there any other evaluation of the living standards that would result from those 40% earnings figures? Well, the short answer to that is no. Learned friend has put in today his table, which has picked up the shelter analysis. Thank you. The shelter analysis, and says, well, look, here we are. Mr. Drabble's clients have an income somewhat above the shelter analysis in Ms. Neal's witness statements. But if we actually look at what those living standards reflect, if the court will pick up, go back to MS 10535. It's in the interveners bundles, the actual passage in the witness statement.
10535?
Yeah.
Yes. You're going to refer us to paragraph 52, aren't you?
I'm going to refer you to 52, 53, 54, and 55.
I thought so.
I won't read them. The point is, the point is sharpest, actually, in 54. The term essential family cost is a bit misleading, as the figures used reflect actual spending of very low-income households and factor in trade-offs and budgeting practices made by low-income households, such as missing meals, choosing to not heat homes, or not replacing worn-out clothes. The figures therefore show the real bottom line of household spend, rather than the cost of meeting needs, not reflective of an adequate budget for a hypothetical family. So what's happening is that the government does no analysis beyond the 40% earnings figure, then defends its position by reference to figures described by Ms. Neal in paragraph 54. And your ladyship will no doubt have got as far as the last sentence of 55. It's a very frugal measure. So for the structure of our case, we say that the cap has a major impact on lone parents, or whatever other cohort you want to use. The effect is to shift their living standards off the ordinary means-tested benefit amounts. I'll come back with just 30 seconds worth on those in just a moment, onto something just above Miss Neal's analysis. And my learned friend also took the court to Lord Dyson in JS in the Court of Appeal, the original benefits cap case in the Court of Appeal. And it is worth just looking at the way in which Lord Dyson describes all this. It's at volume 9, tab 76, MS 3128. Paragraph my learned friend went to is paragraph 105, where he says, we totally agree with the divisional court, the circumstances of these three families do not approach the level of destitution. But if you look at immediately above, where we're getting to is described in paragraph 104. Mr. Wise describes the level of payments made under Section 95 as the destitution threshold. However, the whole purpose of the payments made under Section 95 is to relieve the recipients from destitution. Under Section 95(1), the Secretary of State is empowered to provide support for asylum seekers who appear to him to be destitute or likely to become destitute within a prescribed period. Thus, it can be seen that in the cases of NS and SG, the disposable weekly incomes after the imposition of the cap is roughly equal to the level which it has been determined is sufficient to relieve persons from destitution. So we've gone from an amount produced in the ordinary means-tested benefit system down to something at a level just above destitution. Now, I don't accept, therefore, that the material in the impact assessment or the equality assessment shows a careful consideration of the living standards that would flow from the statutory figures on the face of the primary legislation. Can I move on quickly to another closely related figure, and a closely related point? It's to understand what is happening in terms of applicable amounts in the ordinary benefits. If the court will go to our tables in the core volume at MS 6609, these are the tables which those of you who are working off screens have probably got in colour anyway, and we handed in some coloured versions, however long ago it was, 2 days ago. But just to make good the point, if the court goes to the coloured bars, if those are the right words, you can see the way in which the benefits are made up. So, for example, we have, let's take DS, you have coloured bars showing the various benefits for not working uncapped or not working capped in the two bottom bars. Those benefits are comprised of child benefit, which is not means tested, child tax credit, income support, and housing benefit, so the green, purplish, and blue colours. Housing benefit and income support are both conventional means-tested benefits. That is, they have within their assessment a figure known as the applicable amount, as described by Mr. Justice Henderson, as he then was in Burnip, as the amount the state says is sufficient to live on. It's the basic amount in the calculation of means-tested benefits. And the reference is in our printed case, paragraph 24(1) at MS 8302. Burnip is at volume 6, tab 45. But it will be familiar to some members of the court. Here's the applicable amount, and the basic idea that these main means-tested benefits work on is if you have an income less than the applicable amount, you get income support or whatever benefit it is that takes you to the applicable amount. Housing benefit is tapered, so you can have an income above the applicable amount and still get some contribution to your rent, not have your rent met in full. But
if you're capped, are you being reduced to below subsistence, Mr. Drabble?
you're being reduced to below what those of us in the trade would have called subsistence for very many years. You're being reduced to below the applicable amount. Now, you can have all sorts of arguments about how scientific the applicable amount is. There was some input very many years ago from expenditure surveys and so on. But anyway, the scheme is that you have an applicable amount across the main means-tested benefits, which is your guaranteed income. So if your income is below it, you get brought up to the applicable amount in income support or job seekers allowance, or your housing costs, reasonable housing costs are met in full. I'm paraphrasing like Matt, but that's the basic idea. And so that if you look at the charts, child benefit is not means tested. The effect of the cap is to mean that the totality of the rest of the benefits is reduced below the conventional applicable amount. And as I understand what Baroness Hale was saying in SG, you are being reduced below a conventional view of subsistence income. That's the point. Now, you can argue about whether that's reasonable to do that for a particular category because of the scientific basis. But I mean, that is what's happening.
Well, you referred to those of us in the trade. I've been in the trade as long as you have, Mr.
Yes.
Trouble. That's how we always understood that
Yes.
those benefits were intended and calculated, and that's why I said what I did.
Yes, and
Maybe I was wrong about that, but that's what I'd always understood.
If I may respectfully say so, as a conventional description of the way in which the main means-tested benefits work, that is completely accurate. I mean, it obviously leaves open the question, can you go below that without reducing people to destitution or near destitution? Well, the answer is yes, you can. But that is what you're doing. So going back to the thumbnail sketch of our case, we say, here's a group, say lone parents, being subjected to a cap which takes their income below conventional views of subsistence income because of a need to incentivize the most relevant work, if that's the most relevant and achievable aim, when in very, very large numbers they will not be able to do it. That's the problem. So that's the comment on the tables. And next question is, how many people subject to the cap are realistically able to avoid it? My learned friend continues to use the word choice. He says that lone parents can choose whether to work or not work. Well, the position is that if the court will pick up MS 9551, it's the Institute of Financial Studies. It's the additional witness evidence in reply put in by Mr. Ward. And all I want is the passage at MS 9951 at the end of a document produced by the IFS called Coping with the Cap.
I think that's the Institute of Fiscal Studies, isn't it?
I'm sorry, yes it is. Yeah, I'm sorry.
So,
And
yes. Which paragraph?
sorry, I'm looking at the very last paragraph,
Last paragraph,
on
thank you.
9951, and I'm actually looking at the last 4 or 5 lines.
Thank you.
What this quantitative analysis does not tell us is that the large majority... does tell us is that the large majority of effective claimants responded neither by moving into work nor by moving house. For this majority, it's an open question as to how they adjusted to what were, in many cases, very large reductions in their income. So I did my best on the first day of the case to try to say what the percentage of people who were left on the cap, not moving into work. And it's of the order of 80 or 85%. You can argue about precisely what it is. But the analysis, and the justification analysis, has to proceed on the basis that there's a very substantial majority of the people caught by the cap who do not in fact avoid it. We do not accept, for all the reasons given in the evidence, that it's correct to describe that as a position of choice. There will be very large numbers of people who, for very practical reasons, simply won't find a job. And Baroness Hale in SG described the difficulties, and they are obviously there. And obviously that all relates very closely to the best interests of the child analysis on the basis of the approach taken by my Lord Wilson in Matheson and Lord Carmouth in SG. The issue is, can it be in the best interest of the individual children to expose them to that effect, if that's the right approach to Article 3, a point to which I'll come in just a moment.
I suppose it must also affect the justification analysis, because if the legitimate aim is primarily to incentivize people to move into work, that can only, if you unpack it, mean incentivize people who are capable of responding to the incentive.
Absolutely, exactly. My own friend's submissions came perilously close to positively accepting that if you simply couldn't work, the aim didn't run. It's, now, I mean, that may be too black and white an approach. I don't think I need to go anything like that far, but we do know that there's a very substantial majority who are not working, and we know there are huge numbers of practical difficulties, which has been spelled out at length in the evidence. And that does go very sharply to the justification argument. Now, just a comment without saying any more. Malone refers to the Flexible Support Fund. I'm not going to spend time now. We dealt with this in our crib sheet, as it were, the clip we put around on the first morning. Given the court references to Miss Garnham's evidence about the Flexible Support Fund, one of its striking characteristics is that no one knew it existed until this case. That's a very slight exaggeration, but not very much of one. And you'll find the references in the evidence. The idea that it's a widespread, widely available problem for dealing with the chicken and the egg situation is, in our submission, if you read our evidence, simply misconceived. It's the bottom piece of text on page 11 of our clip. I won't spend more time now going to it. Now, two other major themes. And first of all, we don't accept that our case is synonymous at all. We say that just as in SG, the analysis was, here's a block of people, using rather inelegant language, affected by the measure. Is the impact on those people justified by the aims? And your lordships will find that set out in the judgment of Lord Reed, who refers to Carson at paragraph 7 of SG. the learned friend took you to the quote, and I won't ask your lordships to open it up now. And then in paragraph 14, just asked, just observed that the cap in the form in which has been established affects a higher number of women than men. Whether that differential effect has an objective and reasonable justification depends on whether the legislation governing the cap has a legitimate aim and is a proportionate means of realising that aim. And we say substitute lone parents or children of lone parents for women. Exactly the same exercise is called for now. Nothing called for now, nothing more complicated. And no particular need to have a synonymous approach to it. You just simply ask, does the aim run for the group of people that we have identified, either are all lone parents or children under 5? Those with children under 5. Last point, but quite an important point, the approach to the UNCRC. My learned friend puts forward as his main case that the government has a tenable view of Article 3, that it doesn't apply to general acts affecting children. With respect, it's not a tenable view, both by reason of authority and because of the actual wording of Article 3. Article 3.1 refers in terms to all actions concerning children, whether undertaken by the whole series of bodies, including legislative bodies. So it does in terms apply to a legislative decision. And some members of the court will be familiar with the minimum income requirement case in immigration, which was a Section 55 case, so there was no issue about incorporation. But the submission, my submission was that Article 3 plainly applied to the formulation of the immigration rules, and there was no demur from that. It obviously does. They're more nearer policy than... Yeah, the reference to the minimum income case is MM Lebanon, 2017, One Weekly Law Report 771, and the relevant paragraphs are 45 to 48. And with respect also, Lord Wilson's analysis of Matheson is all in one with that. The 60-day rule, was contained in subordinate legislation.
I don't think Mr. Sheldon actually suggested that it didn't apply to legislative instruments. He said it didn't apply to ones which weren't directed at children.
Let me just understand that.
However, which both the minimum income requirement and the Matheson rule were.
Yes, and so is this one.
And so you say is this
one. Because it's capping child benefit. I mean, I needn't go any further than that.
All right.
You go to Lord Carnworth's analysis in SG, paragraph 126. I'm going to ask the court to open it up. At MS 374, Lord Carnworth said the analysis ignores the specific statutory purpose of the child-related benefits. Well, that's the position here. The decision to cap the child-related benefits is plainly action requiring affecting children. And the more general point, the last point I'm going to be allowed to make, I think, is that as to the impact on on Article 3 on the any justification analysis under Article 14, we continue to rely, with respect, on Baroness Hale's analysis in SG, and the analysis of the line of cases, which, as I said in opening, includes a reference to Gore, which is an express justification case. I mean, it is a case about justification under Article 14, and the material the material that is relied on when the court applies the principles is set out earlier in the report, The report is at volume 16, tab 145, and the material that is relied on is described by the court. Sorry, I'm reading slow. At paragraph 38 and 39, MS 9357, and it includes not only treaties, but relevant decisions of international bodies and so on. So we say that a parallel approach, general comment, can certainly inform the justification argument that's taking place in our case. Slightly more than my quarter of an hour, though that is my reply.
You.
Just endorsing that last comment of Mr. Drabble, I'd remind the court of the reply to the respondent's cross-appeal and the points that we put in writing, just so that the court remembers that they are buried quite deeply into the papers, and the point about actions concerning children is dealt with fairly lengthily there. It's at MS 10339 in the additional bundle 2 of 2. I'm not going to go through that now. The points are well set out there. The court will obviously be aware that it's been a theme of this case from the outset that the respondent hasn't properly understood the interests of children in this case, and the profound impact that the reduction in benefits for families with lone parents of children under 2 can have. Now, in response to that, the best the Secretary of State could do in terms of numbers was the handout that we got this morning on the bar graph, which tells us approximately how many thousands of children were capped at May of 2016. Throughout the whole trawl of these papers, and recalling there is over 10,000 pages of paper in this case, an astonishing amount of paper, in none of those 10,000, 11,000 pages, however many there is, do we see how many children are actually affected. It's quite astonishing. Quite astonishing. What we do know is that there's 36,000 lone parents of children under 2 who have been affected since April 2013, and I think that ran until February of this year. That number will plainly be going up on a daily basis, and given that every one of those 36,000 must be at least one child, there's probably 30, 40, 50,000 or more children that have been affected. So very considerable numbers. We're concerned with very considerable numbers indeed. And the best that my learned friend could do, going through the papers in as much detail as he could, was turn up what was said in the October 2016 equality analysis. And this is at MS 6382 in, bear with me a second, which bundle we're in appendix part 5 in the DA case at page 1871. And the sentence that Mr. Sheldon alighted on under the heading Life Chances and Impact on Children was that for those children whose parents do not respond positively to the cap, they may be adversely impacted with less household income, which may lead to potentially cutting back expenditure, changing location, or maybe schools. And that's it. Potentially cutting back expenditure, changing location, and maybe schools. With no analysis whatsoever of how much expenditure would be reduced, although we do know that the average is between £50 and £60 per household, but that's not understood with respect to these specific types of households, lone parents of children under 2. But more importantly, there's been no analysis of what that actually means for the children, and that's the nub of it. Now, we know from Professor Bradshaw, and I think we know from generally, that poverty in early years has profound and enduring impact. We mentioned this in opening, both in terms of ill health in later life and cognitive development and life expectancy. Now, We're talking here about tens of thousands of children, and yet there's been no analysis whatsoever. None at all. So when my learning friend says, oh, well, they've done all the relevant analysis, they can't be criticised, it simply doesn't stack up. They also say that one of the impacts might be that the children have got to change school. Well, obviously we're talking about children under 2, so that's not relevant. So really it comes down to this cutting back of expenditure, not understood by the Secretary of State at all. And neither is there any understanding of the numbers. So it's that profound concern that underlies this case generally, and must, we say, give rise to an unfairness towards these very vulnerable children. And of course that level of unfairness underpins both the common law and is integral in the convention rights that we're concerned with in this case. And that's probably the meat of the case. But now turning to the detail, what my learned friend said in terms of mitigation and how my clients and people like them can get out of the situation that they're in came down to the Flexible Support Fund and discretionary housing payments. Now, Mr. Drabble mentioned the Flexible Support Fund, and in terms that, frankly, it was the first most people had heard of it when it was raised in this case, and there's evidence to suggest that. But before we come to that, the first important point to make is that the respondent has provided no evidence whatsoever that the Flexible Support Fund has ever been used to mitigate any disadvantage caused to families who are caught by the benefit cap generally, or lone parents of children under 2. There isn't one example of it ever being applied in these circumstances. So to say it's got any significance at all, it must simply be wrong. We have evidence in the papers about the way in which it works, and I'd draw the court's attention to Ellen Broom's statement, paragraphs 5 and 8. That's in the DA Appendix Volume 3, page 32, I think, or thereabouts, MS 5262. She discusses the discretionary nature of the Flexible Support Fund and also the higher cost of childcare for under 2s. And as we know from the Flexible Support Fund guidance, there's a cap on the amount of money that they will spend per week. I think it's about 152. We've got that guidance somewhere buried in the papers. But Miss Broom deals with that quite adequately. And finally, on the Flexible Support Fund, dealing with its low profile, Alison Garnham deals with it in her first statement. I'm not sure if Mr. Drabble mentioned this, but it's paragraph 127 of Miss Garnham's statement, MS 6557. And there's also Miss Carrier, my solicitor's statement at paragraph 48, our appendix, volume 2 at page 27, MS 5018 to 5019. Now, while we can, so the Flexible Support Fund has no realistic part to play at all. Discretionary housing payments have also a very limited part to play, and Mr. Westgate for Shelter yesterday dealt with the point about it being a discretionary fund and so on. Now, Lord Wilson, in questioning to Mr. Sheldon, asked about whether there's been any research about the way local authorities use and apply discretionary housing payments. There's no official research, but what happened, and we've got this in evidence in the papers, is that those instructing me sent freedom of information requests to every local authority in England. And we've got the product of those requests in Miss Carrier's witness statement, particularly between paragraphs 21 and 22, but I would invite the court to read the paragraphs surrounding that. That's in Appendix Volume 2 at page 499, MS 5010, and you'll see the very patchy nature of the way in which the discretionary housing payments are made, frankly, if at all. And the short point there, in summary, on DHPs, is that they are simply an inadequate means of dealing with a systemic problem. We're not talking about a few hard cases here. We know we're talking about tens of thousands of of cases. Maloney Friend also placed considerable reliance, indeed it may be even said to place exclusive reliance on the 41% figure that we see repeated throughout the respondent's case, both in evidence and submissions. For a complete debunking of this figure and showing how misleading it is, can I ask the members of the court to read James Harvey's first expert report, specifically at paragraphs 25 through to 36, that is. That's at MS 5082 to 5087, Appendix Volume 2, pages 571 to 576. And we'll see how completely irrelevant that figure is for present purposes. But in any event, there is no evidence whatsoever, statistical or otherwise, with respect to the impact on lone parents of children under 2. They simply haven't got the figures. Maloney Friend then mentioned the joint committee document. This was the document you'll recall that we mentioned yesterday and Maloney Friend handed in this morning, the memorandum of the Joint Committee on Human Rights, 8th of September 2015, and relied particularly on paragraph 77. And this was supposed to be part of the information gathering exercise before we come on to consider justification. It's one short paragraph. Again, we see repeated like a mantra, parrot fashion, is what we say is misleading 41% figure. But in what it says with respect to compliance with the UNCRC, which we'll come on to in a moment, he says that the government has fully considered its obligations under the UNCRC, in particular Article 3 and Article 27. The government considers that 20 to £23,000 is a sufficient amount for families to live on, etc. Now, just analysing all that, all it says is that the UNCRC has been fully considered. Now, we've seen that in a number of places. The UNCRC has been considered. Again, it's like a mantra. They just keep saying it. Just because they say it doesn't mean they've actually done it. What we have to do is look at the substance. So when we look at the substance of this, what do they actually say? All it says is that the government considers that £20 to £23,000 is sufficient amount for families to live on. Well, that doesn't deal with the best interests of children. It doesn't even begin to consider it. Never mind answer what is in the best interest of children, and never mind then to go on to the next stage to consider whether the best interests of the children should be a paramount consideration. All it says with respect to best interest is the best interest of children overall is to have parents in work, and work remains the surest route out of poverty, which may or may not be correct, but that's not the point in issue here. What the point in issue is whether it's in the best interest of children to have the family income reduced as it is. So that's a very unsatisfactory and inadequate evidence from the respondent that they've fully had regard to the interest of children generally in the UNCRC in particular. Maloney Friend then took the court to the survey, which on its face is the in-depth interviews with people affected by the benefit cap. What he didn't take the court to was a very important paragraph at page 11 of this document, MS 5640, paragraph 1.2, which says in the first place that a total...
Mr. Wise, hold on, I'm sorry. Which bundle are we in here?
Oh, I'm sorry, my lord. Appendix Part 4.
Thank you.
Just pause a moment while you turn it up. That's DA Appendix Part 4.
Yeah, sure.
Does your lordship have that? MS 5640 for those working online. And there's 2 points to draw from this paragraph. Firstly, we see on the second line that it's based on a total of 50 interviews conducted between April and June 2014. But can we pick it up 4 lines from the bottom? What it says on its own face, it is not possible to draw robust generalisations from a small sample such as this. His very own survey says that it shouldn't be used in the way that the department and the respondent here are now using. It's quite extraordinary. And Mr. Harvey, James Harvey, in his expert report, also draws criticism, makes criticism of the way in which these research methods have been deployed in this case. That's Harvey's first report again, Appendix Volume 2, page 570 to 571, MS 5081 to 5082, where he says the evidence isn't robust. So we should treat that evidence, or what's said in that survey, with a great deal of caution, give it any credence whatsoever, frankly. The next point in time was the point that a number of members of the court were concerned with after the adjournment at lunchtime, particularly my Lord Hodge, and that was what the court's doing in proportionality cases and Flimenos cases. I think is perhaps a short way of putting it. Well, our short summary of what the court should be doing is it's to determine whether in this case, that the court is to determine whether the failure to treat lone parents of children under 2 differently to others affected by the cap is proportionate, or in other words, strikes a fair balance between the individual and the community as a whole. Quite straightforward. Now, we say that's not to be done manifestly without reasonable foundation. That's a matter for this court to determine, looking at the evidence as a whole, and providing proper due respect to the decision makers. So as a matter of principle, it seems to us to be fairly straightforward. Certainly not as straightforward for the court to determine, but I don't think in terms of what the court is tasked to do, it's particularly difficult. I see that...
You're nearly out of time, Mr. Hoyce.
Sorry. Manifestly without reasonable foundation, we've dealt with. There's no, I think, as my lady observed, it's very difficult to see why, as a matter of principle, the law as elucidated in the Welsh asbestos case and the A and B case should be any different in those sorts of cases than it should be in these sorts of cases. Welfare benefits of no particular characteristic that marks them out from other cases that concern the state expenditure and social policy. On rationality, the only submission that my learned friend made was that on a bare Wednesbury analysis, we don't get home for the reasons he'd already said. But of course, we say this court shouldn't be looking at it on a bare Wednesbury analysis. It should be done as a matter of proportionality for the reasons we've set out, and at very least to a very intense level of scrutiny, and remind the court what Mr. Justice Green said in the BAT case again, detailed judicial engagement with the facts, which is particularly pertinent here. That, I think, covers the main areas. One point that we didn't raise in opening, and that is relief, and what we're actually asking the court to do.
Well, we can't get onto that now. We've got to 4 o'clock. This is the end of the day.
You have it in the
We'll have to read we'll have to read what you all say.
last paragraph of our case, my lady. I was only just...
It usually is the last paragraph of your case.
Absolutely. If there's nothing else I can assist you with, my lady, that's all our submissions.
Well, I'm sure everybody could give us even more assistance than they already have in this complicated and extremely difficult and sensitive case. But we're grateful to you all, not only those of you who've been on your feet, but those of you who've been working and beavering away behind and contributed to the mass of documentation that we have to consider. We will now go away and consider it and let you know the outcome as soon as we can. The court will now adjourn.